So good evening, everyone. Uh, I hope that you are all staying home safe and fine. And well, today's topic is the Sabrimala judgment. The Sabrimala judgment, one of the landmark judgments in the recent years of the Supreme Court, and one of the biggest controversies so far. And because in these cases we have seen that the older practices, which were based mainly on whims and caprices of the older and antediluvian thoughts, have been done away with completely, and the judgments have been given in the light of the the third world fundamental rights and the third world um, era, the 21st century era. So we are talking about upholding the fundamental rights of the women, and Sabrimala judgment is one of the landmark judgments to understand how far it is important to make sure that religion, even in religion, we have to ensure basic equality between men and women, and all that belongs to men equally belongs to women as well. If the men have the right to visit the sanctum sanctorum of any religious place, exactly the same way and up to the same extent, women also deserve the same rights to visit the sanctum sanctorum of any place. Like what happened in Kerala, or what happened in Sabrimala temple, was that the temple is belongs to deity Lord Ayyappa, who happens to be a virgin, and it was prohibited since a very old time. It was prohibited for the women aged 10 to 50 years. 10 years, like below 10 years, people, the girls were allowed, and above 50 years, the women were allowed. But this age group of 10 to 50 years was not allowed inside the sanctum sanctorum of the temple, because it was believed that Lord Ayyappa, who happens to be a virgin deity, cannot tolerate a menstruating woman inside the premises of the temple, and it is going to be unholy for all the, unholy for the deity who is sitting inside the temple. So definitely this was considered to be unconstitutional, because the women, a group of women, raised this issue before the Supreme Court and said that this practice and these notions are antediluvian, and they are completely, dusted with the older thoughts, older notions, jaded old notions of of older times. And we need to look at these things with a modern perspective, and it's about the rights. It's about the rights of the women. So far as the men have the right to practice their religion peacefully and freely, so also the women also have this right to practice their religion freely. Okay, now I'm starting to share this screen. So I hope this is visible. This is Indian Young Lawyers Association and others versus the state of Kerala and others. Now, the petitioner, the main principal petitioner, happens to be the Indian Young Lawyers Association, and others. Others were also there versus the state of Kerala and others. Now, this 2018 judgment of the Supreme Court. The case was filed in 2006 by the Indian Young Lawyers Association through public interest litigation before the Honorable Supreme Court of India. You all must be knowing what is a public interest litigation. I told you in the earlier sessions also that public interest litigation is an innovation of the Supreme Court. Borrowed, the concept has been borrowed or taken from the United States of America and the person who brought this, who imported this concept into the Article 32 of the Constitution, was Justice P.N. Bhagwati. So Justice P.N. Bhagwati introduced this concept of public interest litigation, where the fundamental rights of huge number of people or masses at a greater level are violated together. So in that case, you don't need to file all the writ petitions separately. One public interest litigation would work, bringing all the litigants under one purview and filing a public interest litigation. Although this phrase this name public interest litigation, you cannot find this phrase, you cannot find this name public interest litigation anywhere in the constitution. You might find it in the commentaries, but you won't find it in the original text of the constitution. Article 32 is specifically talks about individual writs, but all these writs have been, have been broadened enough. Their scope and their procedure of filing the writs have been broadened to make it into a public interest litigation. So there was a public interest litigation because the fundamental rights of the women at a larger scale, of all the women at a larger scale, was violated, and this PIL was filed in 2006. The case deals with an important aspect, that is entry of women in Sabrimala temple. There were many issues raised in which it was argued by petitioners that provisions related to the restriction of the women entry in temple are unconstitutional, as it violates Article 14, Article 15, Article 17, 25, 26 of the Indian Constitution. So they basically, and straight away there is no confusion about it, that you are allowing men, all the men, you are allowing a particular age group of women inside the temple, but you are not allowing a particular sect based on sex, and you are also categorizing them into a certain age group, and you are absolutely prohibiting them from entering into inside the temple. So this was clearly came out to be in violation of Article 14 of the Constitution of India. Article 14 says that the state shall not deny to any person equality before law or the equal protection of laws. Article 14, like, we have two phrases, we have discussed this earlier also in the earlier sessions, that equality before law and equal protection of laws. Equality before law is like everybody is equal before law. This is one of the simplest phrases in the Constitution. Equal protection of laws is that we have to classify the society, but this classification should be reasonable based on intelligible differentia. So the Supreme Court put this, this classification into on the to the test of intelligible differentia, whether the classification of the women of age group from 10 to 50 years was held to be reasonable, and whether it was based on intelligible differentia or not. So Article 14 was held to be violative. It was alleged to be violative, in fact, firstly in the petition. Then Article 15, because it was a clear discrimination on grounds of sex, because it expressly prohibits any discrimination on grounds of inter alia sex. Article 17 prohibits untouchability. So untouchability is not exclusively for the lower caste, people belonging to the lower caste, or the kind of untouchability they have been facing. It may be it may come out to be in any form. Okay, it may be like the women of age group from 10 to 50 years, because they are subject to menstruation, they are being prohibited, they are being treated as untouchables because they are not being allowed inside the temple. So this also came out to be a form of untouchability. So Article 17 was also invoked. Article 25 gives you freedom of religion, freedom of conscience, freedom to profess, practice, and propagate your religion the way you want to. So why not the women have these rights? Article 26 of the Constitution, Article 26 again gives you the right to, to like decide the religious matters yourself. Okay, you have the right to decide the religious matters yourself, provided that no further fundamental right of any single person gets violated. So the Sabrimala temple, where is this Sabrimala temple? The Sabrimala temple is situated in the Periyar Tiger Reserve in the Western Ghat mountain ranges of Pathanamthitta district, Kerala. So one of the very famous, this is one of the very famous temples, and this is situated in the Periyar Tiger Reserve in the Western Ghat mountain ranges of Pathanamthitta district, the district in the Kerala where it is situated. It is Pathanamthitta. This temple is famous for Lord Ayyappa. It forbids the entry of women in their menstruating age that are between the age of 10 to 50 years, stated that is a place of worship. Okay. Now, since they happen to be a form of a class of women who were exempted, who were not allowed, who were prohibited from entering into, because it is a place of worship. And let us understand the background now. Since I told you that Lord Ayyappa happens to be a virgin Lord, virgin deity, and he never tolerated any, any sort of unholiness around him. So it was believed that it was not feasible enough to allow the menstruating women from 10 to 50 years to visit the sanctum sanctorum inside the temple, and create any sort of unholiness around Lord Ayyappa. So because it was considered a great disrespect to the virginity of Lord Ayyappa. Okay, now the background. The Sabrimala temple is one of the most well-known pilgrimages place of Hindus. Okay, well-known pilgrimages place of Hindus. The Sabrimala shrine, which is one of the most famous temples in Kerala, had restricted women of menstruating age from entry. Several women tried to enter the temple but could not because of threats of physical assault against them, because people in India are very sensitive regarding these practices and customs. So they, in fact, tend to, resort to violence at sometimes in order to protect their old customs, howsoever jaded and antediluvian they might be. So in 1991, a group of 5 women lawyers had moved to the apex court, challenging the decision of the Kerala High Court. The court gave judgment in favor of the prohibitory, and said that these restrictions are not discrimination to the Constitution. They said that this forms a reasonable classification based on the intelligible differentia. The reason is that these class of women, they are subject to menstruation, and it is not feasible, it is not appropriate to allow their entry inside the temple, because this might create any sort of unholiness. So this is not a discrimination on grounds of Constitution, because Constitution also brings forth certain sorts of restrictions on the practice of fundamental rights. In 2006, the ban was opposed by the Young Lawyers Association, appealing that Rule 3B of Kerala Hindu Places of Public Worship Authorization of Entry Rules 1965 states that women who are not by custom and usage allowed to enter a place of public worship. Later in 2008, the PIL was heard by a constitutional bench, including the former Chief Justice of India, Deepak Mishra. Now, uh, see, this actually, there was a rule, it's Rule 3B of Kerala Hindu Places of Public Worship Authorization of Entry Rules 1965. Okay, Kerala Hindu Places of Public Worship Authorization of Entry Rules 1965 actually and expressly prohibited women to follow the customs and usages and not to enter any place of public worship. Okay, but in later years, in the recent years, the constitutional bench, which was headed by former Chief Justice of India, Deepak Mishra, this PIL was also heard. Okay, now petitioners. Petitioners are the Indian Young Lawyers Association, Dr. Lakshmi Shastri, Prerna Kumari, Alka Sharma, and Sudha Pal. These were the petitioners. Okay, Indian Young Lawyers Association, Dr. Lakshmi Shastri, Prerna Kumari, Alka Sharma, and Sudha Pal. Then respondents were the state of Kerala, Travancore, Devasam Board, Chief Tantri of Sabrimala Temple, District Magistrate of Patanam Thetta, Nair Service Society, Akhil Bharatiya Ayyappa Seva Sangam, Ayyappa Seva Samiti, Ayyappa Puja Samiti, Kerala Kshetra Smarak Shan Samiti, Pandalam Kotaram Nirvahak Sangam, Sabrimala Custom Protection Forum. These are all very typical names from South India. So you know actually the main respondent was the state of Kerala itself. All others were the parties who intervened in the matter, who wanted to intervene in the matter in order to protect this custom, this older custom. So these are there's a list of petitioners and the respondents. Okay, now Issues before the court. Whether the exclusionary practice, which is based upon a biological factor exclusive to the female gender, amounts to discrimination and thereby violates the very core of Article 14, 15, and 17 and protected by morality as used in Articles 25 and 26, 6 of the Constitution. See, this is one of the a ground for debate and a thorough discussion that whether first of all, whether these kinds of practices are protected under Article 14 of the Constitution, because we have classified a group of women, and there is a group of women which is biologically distinguished from the rest of the people, including women who are below 10 and above 50. Okay, so they are absolutely different based on the biological factors. So whether this is based on intelligible differentiation, yes, it might be said that from the science perspective, this might be like, this might seem like this is based on biological difference, and this is based on like this might be called a reasonable classification based on intelligible differentia. Then next was the Article 15 of the Constitution. Article 15 of the Constitution prohibits certain discriminations inter alia, including sex. So this was held to be like whether the prohibiting women amounted to discrimination, and Article 17, because Article 17 does not exclusively talk about the lower caste of the people who faced certain sorts of untouchabilities, and they were not allowed in the ancient and medieval times to enter inside the temples and places, public places. But it is also about, untouchability may come up in any form. We have Protection of Civil Rights Act 1955, which was the Prohibition of Untouchability Act 1955, and then in the 1975 it was renamed as Protection of Civil Rights Act 1955. So this Protection of Civil Rights Act 1955 does not exclusively talk about the prohibitory discriminations against the SCs and STs, but also talk about any form of untouchability that may come up in any form against anybody. So this is also a kind of untouchability, because we are restricting women, we are treating them as untouchables, because we are not allowing them at a public place of religious nature. So Article 17 was also invoked, and yes, protected by morality as used in Article 25. This is yet again another form, or a thing to be discussed thoroughly, that Article 25, it is subject to three things, because Article 25 begins with subject to public order, health, and morality. It's not absolute. None of your fundamental right is absolute. Right from 14 till 32, none of the fundamental right is absolute. They are not absolute. Not even 21, because 21 also says that no person shall be deprived of his life or personal liberty except according to the procedure established by law. That means if the procedure of law is established, then life can be taken away, your personal liberty can also be taken away. So not even 21 is absolute. No fundamental right is absolute. Not even Article 25. We are a secular nation. We have certain religious freedoms, but our religious freedoms are subject to certain restrictions, and the article begins with those restrictions. It says that subject to public order, health, and morality. That means the state has kept its prerogative reserved and saved, that if there is any threat of public, or a threat to the public order with from your religious practice or your religious freedom, it might be curbed. Then again, if it is against if it is against some the generally the health of the people, like for example, there are certain practices which are absolute, which are not healthy. In fact, they come out to be against very fatal to the health of the people in general. So there are certain kinds of things like continuous noise pollution inside the temples, or excessive use of loudspeakers in the streets. It might be like any sort of Muslim congregation or a Hindu congregation. So these kinds of things, because you are adding to the noise pollution, and you are creating anxiety and sleeplessness and insomnia to the people. So if you are doing this, then, and if the state finds it against the health of the society in general, then it might be curbed. Okay, so Morality, then comes morality. Now morality is something which is not defined in the constitution. This is yet again a matter of discussion, that morality and decency, like these two words have appeared under article 19.2 of the constitution also as one of the reasonable restrictions on the freedom of speech and expression. So decency and morality are the most vague terms. The Supreme Court has said that these are the most vague and ambiguous terms which cannot be defined and have not been defined anywhere. So how can you assess that something is moral and something other is immoral? It is very difficult. We have to assess the situation. We have to analyze it. We have to decipher the problems inside a particular situation and find out whether one particular practice amounts to, fulfills the parameters of morality, and if there are certain parameters of morality, where these parameters have come from. So morality is one of the most debatable issues in the constitutional discourse. Article 25 also says that if one practice, for example, if one of the practice of one particular community, one religious practice of one particular community forms the essential part of one's religion, can it, like, for others it might be immoral. For others it might be immoral. It might not be feasible for them to witness such kinds of things inside the society openly. So it is very difficult. We have to decide upon the essentiality. We have to also decide about the morality. So whether, now coming back to the Sabrimala issue, that morality as used in article 25 and 26.6 of the constitution, what is this article 25? What is this morality under article 25 and 26.6 of the constitution? Because your practice, your notions, because under article 26 of the constitution you have the right to decide the religious affairs of your own religious affairs yourself. Okay, so you all have this right, but morality, like for example, these age group of this women of age group of 10 to 50 years have been restricted on certain moral grounds. Whether this amounts to actually this amounts to morality or not, this is one of the aspects protected by morality as used in article 25 and 26.6 of the constitution. Whether this restriction violates the provisions of Kerala Hindu Place of Public Worship Act 1965, whether this restriction violates the provisions of Kerala Hindu Place of Public Worship Act 1965, because Kerala Hindu Place of Public Worship Act 1965 has certain provisions, and this whimsically made restrictions, whether they violate the provisions of Kerala Hindu Place of Public Worship Act 1965. Then comes whether the Sabrimala temple has a denominational character, because any place of worship, any place of public worship, if it has a denominational character, that means it belongs to the particular class of people in general. Then you cannot restrict somebody. Like if you have a house and if you have a religious places of your own for yourself inside your private premises, then that solely belongs to you. No other person can come and claim it that this belongs to the community in general, and anybody who wishes to worship can visit your place inside your private premises. That is not the case. So whether the Sabrimala temple has a denominational character or not, it has to be seen कि ये इसका कोई डिनोमिनेशनल कैरेक्टर है कि नहीं है. अगर डिनोमिनेशनल कैरेक्टर है तो यहाँ पर हर किसी को अलाउ करना पड़ेगा, whether the Sabrimala temple has a denominational character or not. Whether Rule 3 of the Kerala Hindu Places of Public Worship Authorization of Entry rules permits religious denomination to ban entry of women between the age of 10 to 50 years. We have to assess. These were the issues framed before the court, that के ये जो Rule 3 है Kerala Hindu Places of Public Worship Authorization of Entry rules का, क्या ये परमिट करता है religious denomination को, किसी भी religious denomination को, कि वो अपनी एंट्री, जो किसी की भी एंट्री, अब यहाँ इस केस में विमेन की एंट्री है बिटवीन द एज ऑफ 10 to 50 years की जो विमेन है, उनकी एंट्री को बैन किया गया है. तो क्या ये परमिट करता है या नहीं करता है, ये सारे इश्यूज यहाँ पर फ्रेम किए गए थे. तो आई एम रिपीटिंग द इश्यूज. Whether the exclusionary practice which is based upon a biological factor exclusive to the female gender amounts to discrimination and thereby violates the very core of Article 14, 15, and Article 17 and protected by morality as used in Article 25 and 26(6) of the Constitution. Whether this restriction violates the provisions of Kerala Hindu Place of Public Worship Act 1965, whether the Sabrimala temple has a denominational character, whether Rule 3 of the Kerala Hindu Places of Public Worship authorization of entry rules permits religious denomination to ban entry of women between the age of 10 to 50 years. Okay, now arguments by the parties on the issue. There is a question whether a temple a public place when the property is vested with the idol. Exactly. See, you can have your own temples or your own places of worship built up inside your private premises. Okay, you can do that, but that place of public worship solely belongs to you. The people from your community cannot come and claim that this, since this is a religious place of worship, and so this belongs to the public in general or to the community in general. This cannot happen. But if it is, if a temple has a denominational character and the property is based, property is vested with the idol, it is now it is now everybody's right in the community to visit that place. So since it is everybody's right, it is a public place. It does not belong to one particular individual. The property is vested with the idol, and so everybody has a right to visit that place, and it is a public place. It is a public place. Okay, Yash Bhargav, it is a public place. When the property is vested with the idol, it is a public place. Arguments by the parties on issue. Now, I'm just reading them. Arguments in favor of women entry. What were the arguments raised? The arguments given in the favor of women entry by the petitioners were menstruation is not impure, and that women should have equal rights to enter in the Sabrimala temple. In our society, since ages, women had to struggle or fight for their equal position at public platforms. It is not about the representation, but is also about the ideological fight with the rules and customs in patriarchal society. Basically, these petitioners argued that, first of all, we have a mindset that this biological phenomenon is impure, and this should not be considered as holy enough to allow women inside any place of public worship. And then secondly, that women should have equal rights to enter into the Sabrimala temple, because once this mindset is done away with, there is no reasonability or there is no ground to believe that women should then be restricted at any at any cost. So they should have equal rights to enter in the Sabrimala temple. Then in our society, since ages, women had to struggle or fight for their equal position at public platforms. So basically, this restriction has its origin somewhere in the antediluvian and jaded thoughts and notions from the ancient society. And therefore, since women there were also fighting for their rights, and today the women have come down to fighting for their rights till this present day. So it is not about the representation, but it is also about the ideological fight with the rules and customs in patriarchal society, according to which women remain subordinates. This case has been fight against the patriarchal philosophy of the religious order, which prohibits the entry of women into the temple. The case provided the Supreme Court with a chance to balance the gap between constitutional ideals and social reality. Now, it was the job of the Supreme Court to balance both the issues. The social reality is something else, the constitutional ideals are something else, and they stand in contrast with each other. So it is sometimes very difficult for the Supreme Court to uphold the constitutional ideals and do away the social reality altogether. The Supreme Court somehow has to make a balance, strike a balance, so that there should not arise a discontentment amongst the masses regarding the judgments of the Supreme Supreme Court time and again, because if it continues to happen, this might give rise to the infidelity at a mass level against the Supreme Court's orders and judgments. So then Article 14, the Constitution of India, 1949, equality. These are the arguments of the petitioners. Equality before the law. Equality before law, the state shall not deny to any person equality before the law or the equal protection of laws within the territory of India. Prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth. Like Article 14 and 20, 14 and 15. I told you that equality before the law is one says that the state shall not deny to any person equality before the law or the equal protection of laws within the territory of India. So in fact, if it is not fitting this, if it is not getting fitted inside the notion of equal protection of laws, because the classification does not seem to be reasonable, therefore it should be done away with, because we have a mindset that this biological phenomenon is impure, and therefore that is why we have classified them as different, biologically different, but that is not the case. So once that is not the case, once it is proved that that is not the case, then they are also, this classification is also not protected under equal protection of laws. Then there is a prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth. And sex is one of the grounds for prohibiting the discriminations. And यहाँ पर exclusively sex के basis पे discriminate किया जा रहा है, तो this is absolutely yet again a matter of great concern. Then Article 25, freedom of conscience and free profession, practice, and propagation of religion. This belongs to everybody. This belongs to everybody, not solely men, or not solely a woman of particular age, below particular age, or above particular age. This belongs to all the people in general. All the people in general. So once this belongs to all the people in general, it's freedom of conscience, free profession, practice, and propagations, then why did anybody had the right to decide that who can visit which place and who cannot, right? So Article 25 of the Constitution is yet again another important element here. Then all persons are equally entitled to freedom of conscience and the right freely to profess, practice, and propagate religion. Article 15, prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth. The state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, and place of birth. No citizen shall, on grounds only of religious, race, caste, sex, place of birth, or any of them, be subject to any disability, liability, restriction, or condition with regard to access to shops, public restaurants, hotels, and places of public entertainment. See, यहाँ पर कितने सारे ग्राउंड्स हैं, इनके बेसिस पर किसी को डिसेबल नहीं किया जाएगा. यहाँ पे वुमेन को डिसेबल किया जा रहा है. डिसेबल किया जा रहा है कि that she cannot visit. She is not able to visit. यहाँ लाइबिलिटी नहीं इम्पोज की जाएगी, रिस्ट्रिक्शन नहीं लगाया जाएगा, रिस्ट्रिक्शन लगाया जा रहा है, कंडीशन नहीं लगाई जाएगी. हर चीज आपके जो फंडामेंटल राइट्स हैं वो कंडीशनल एंजॉयमेंट्स के लिए नहीं है. कंडीशनल एंजॉयमेंट्स होता है कि मतलब अगर आप ये शर्त पूरी करें तभी आप ये वाला फंडामेंटल राइट एंजॉय कर सकते हैं. ऐसा बिल्कुल नहीं है. योर फंडामेंटल राइट्स आर नॉट सपोज्ड टू बी एक्सरसाइज्ड ऑन बेस्ड ऑन कंडीशंस. We have the right to exercise and we have the freedom to exercise our fundamental rights, enjoy our fundamental rights unconditionally. So this means that no restriction, no condition, no disability, no liability, but all seem to have gathered here in case of Sabrimala temple. With regard to access to shops, public restaurants, hotels, and places of public entertainment, कहीं पर भी जाने से नहीं रोका जाएगा. दुकानों में, रेस्टोरेंट्स में, होटल्स में, पब्लिक एंटरटेनमेंट की जगह पे जब आप पब्लिक प्लेसेस पे नहीं रोक रहे हैं, तो जो एक डिनोमिनेशनल कैरेक्टर का टेम्पल है या कोई भी रिलीजियस प्लेस है, वहां पर आप कैसे रोक सकते हैं? ठीक. Then Article 17, abolition of untouchability. Untouchability is abolished and its practice in any form is forbidden. The enforcement of any disability arising out of untouchability shall be an offence punishable in accordance with law. Untouchability का जो ये किसी मतलब पहले प्रैक्टिस की जाती थी, बहुत प्रैक्टिस की जाती थी ओपनली, जो हमारा वैदिक सोसाइटी थी। तो उस वैदिक सोसाइटी में जो डिविजन्स थे, वर्ण सिस्टम बेस्ड ऑन कलर, ब्राह्मण, क्षत्रियास, वैश्य एंड शूद्र। तो ये जो ब्राह्मण्स और क्षत्रियास जो राइट्स एंजॉय करते थे वो वैश्य भी नहीं करते थे, ये तो खाली ट्रेड तक सीमित रहते थे, और जो वैश्य करते थे वो शूद्र तो वो बिल्कुल ही नहीं करते थे। तो शूद्र जो थे दे वर सब्जेक्ट टू एक्सप्लॉयटेशन और अनटचेबिलिटीज और बहुत सारी बातें इनके साथ होती थी। तो ये अनटचेबिलिटी बहुत पुराना जो है टैबू है हमारी सोसाइटी का, जो एंशिएंट टाइम से हमारे यहाँ चला आ रहा है, अभी भी एग्जिस्ट करता है बहुत सारे रूरल पॉकेट्स में। लेकिन अबॉलिशन ऑफ अनटचेबिलिटी का मतलब ये नहीं कि खाली हम यहाँ एससीज या एसटीज की अनटचेबिलिटी की बात कर रहे हैं, किसी भी फॉर्म में। यहाँ पर लिखा हुआ है आर्टिकल 17 में, untouchability is abolished and its practice in any form is forbidden. The enforcement of any disability arising out of untouchability shall be an offense punishable in accordance with law. Okay, so if you are disabling somebody because of untouchability, yahan par bhi same case yahi ho raha hai. You have to understand this. The petitioners argued, they are trying to explain why they have invoked Article 17 here, because a class of women have been subject to disability arising out of untouchability, because they are considered in that age group, they are considered to be untouchables, unholy, impure. So it is because of the untouchability that you are not allowing a class of women to enter inside the temple. So any sort of untouchability, this is an untouchability, and it may come out in any form, and this is also one of the forms. The enforcement of any disability arising out of untouchability shall be an offense punishable in accordance with law. Okay. What is the law? Protection of Civil Rights Act 1955. It explains what are the acts that constitute untouchability, and any matter incidental to and consequential thereto are also included within that offense, and they are also punishable. It also prescribes punishment. It is a penal offense. Then Article 26, freedom to manage religious affairs. Like I told you, we have the right to manage your own religious affairs. Freedom to manage religious affairs subject to public order, morality, and health. Every religious denomination or any section thereof shall have the right to decide about your own religious affairs. Like, for example, the Sabrimala temple is one of its denominational temple, and even if it has the right to decide that who can enter and who cannot enter the temple, is one of the rights which is given to them under Article 26. But these decisions should be based on public order, morality, and health. If they are fulfilling these kinds of criteria, their decision seems to be constitutional, and if it is not, the decision is prima facie unconstitutional. So यहाँ पर morality को ground बनाकर ये restriction लगाया गया था. तो सवाल ये है कि जो morality को लेकर यहाँ पर restriction लगाया गया था, क्या ये morality में actually fall करता भी है या नहीं करता है? क्या ये moral है भी कि नहीं है? क्या चीज मॉरल है, क्या चीज इमोरल है, ये डिसाइड करना बहुत जरूरी है. मॉरलिटी के जो नोशंस हैं वो डिफर करते हैं. हो सकता है कि कुछ अजीब सुपरस्टिशियस या पुराने ख्यालात हों जो आज के जमाने में साइंटिफिकली फिट ना बैठते हो. एग्जैक्टली वही यहाँ के केस में हुआ है. Okay, the provision in Kerala Hindu Place of Public Worship Act 1956, which support restriction to women's entry in the temple, is unconstitutional as it violates Article 14, 15, 25, and 26 of the Indian Constitution. One of the arguments from the side of the petitioner that Lord Ayyappa temple was not separate religious practices performed in Sabrimala temple at the time of puja, and other religious ceremonies are not different from other religious practices performed in other Hindu temples. So, other हिंदू टेम्पल्स में जब अलाउ किया गया है तो साबरीमाला में क्यों नहीं अलाउ किया गया है? ओके, नहीं, आर्ग्यूमेंट्स अगेंस्ट वुमेन एंट्री, एंड देन आई एम रीडिंग, उसके बाद हम जजमेंट पर आ जाएंगे. दीज आर स्मॉलर पैराग्राफ्स. सी, the arguments given against women entry by respondents such religious practices are not as old as it is a tradition to respect god or goddess of temple. Men are also restricted to entry and worship in several temples. For example, Brahma temple, पुष्कर में ब्रह्मा टेम्पल है, वहां पे मेन भी अलाउड नहीं है. तो इनका कहना यह है कि ये कोई ऐसा नहीं है कि हम खास मकसद से एक वुमेन को, क्लास ऑफ वुमेन को या ग्रुप ऑफ वुमेन को डिसेबल करने के लिए रोक रहे हैं. ऐसा बिल्कुल भी नहीं है. हम डिसेबल करने के लिए बिल्कुल भी नहीं रोक रहे हैं. हम जो हैं वो गॉड या हमारा जो मकसद है वो किसी को डिसेबल करना नहीं है, या हमारा जो मकसद है वो डिस्क्रिमिनेशन नहीं है ऑन ग्राउंड्स ऑफ सेक्स, बल्कि हमारा जो मकसद है वो गॉड या गॉडेस जो है टेम्पल की, उनकी रिस्पेक्ट करना है, और वही ट्रेडिशन हम मेंटेन किए हुए हैं। अब उसके लिए हमें कुछ भी करना पड़े तो वो आपको मकसद देखना है, आपको इंटेंशन देखनी है, आपको ये नहीं देखना है। ब्रह्मा टेम्पल में जब पुष्कर में जो ब्रह्मा टेम्पल है वहां मेन अलाउड नहीं है, तो यहाँ पे विमेन अलाउड नहीं, तो ऐसा नहीं है कि खाली विमेन के साथ ही डिस्क्रिमिनेशन हो रहा है। दूसरी बात ये है कि देयर इज नो वायलेशन ऑफ आर्टिकल 15, 25 एंड 26 ऑफ द इंडियन कॉन्स्टिट्यूशन, एज द रिस्ट्रिक्शन इज ओनली इन रिस्पेक्ट ऑफ विमेन ऑफ अ पर्टिकुलर एज ग्रुप एंड नॉट विमेन एज अ क्लास। ओके, सो दे सेड दैट अगर हमें विमेन के अगेंस्ट डिस्क्रिमिनेशन करना होता तो हम 10 से कम साल की बच्चियों को या 50 साल से ऊपर की जो विमेन है उनको भी अलाउ ना करते, लेकिन हमने किसी ऐसा ऐसा बिल्कुल नहीं किया। विमेन अलाउड है, लेकिन एक पर्टिकुलर क्लास ऑफ पीपल को हमने एक साइंटिफिक बेसिस के ऊपर हमने रिस्ट्रिक्ट किया है। So the provisions in Kerala Hindu Place of Public Worship Act 1965 also support this restriction, ये उनका कहना था। ठीक है, अब ये देखिए कि जजमेंट क्या आया, रेशियो डिसेंडाई, ये लीगली बाइंडिंग होता है। रेशियो डिसेंडाई क्या होता है? लीगली बाइंडिंग होता है। रेशियो डिसेंडाई इज द रूल ऑफ लॉ ऑन विच जुडिशियल डिसीजन इज बेस्ड, इट इज लीगली बाइंडिंग। ऑन 28 September 2018 the court delivered its verdict in this case by 4:1 majority, which held that the practice violated the fundamental rights to equality, liberty, and freedom of religion. Article 14, 15, 19, Clause 1, 21, and 25, Clause 1. It has struck down Rule 3B of the Kerala Hindu Places of Public Worship Act as unconstitutional. Rule 3B allowed for Hindu denominations to exclude women from public places of worship if the exclusion was based on custom. Okay, so 28 September 2018 को ये जजमेंट आया और उस 4:1 की मेजोरिटी से आया, जहां पर उन्होंने कहा कि जो फंडामेंटल राइट्स टू इक्वालिटी, लिबर्टी और फ्रीडम ऑफ रिलीजन है वो सीधा सीधा यहाँ वायलेट हो रहा है। 14, 15, 19 क्लॉज 1 फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन है उसमें, 21 राइट टू लाइफ एंड पर्सनल लिबर्टी, 25(1) फ्रीडम ऑफ कॉन्शियंस, ये फ्रीडम ऑफ कॉन्शियंस, प्रैक्टिस, प्रोफेशन एंड प्रोपगेशन, ये सब वायलेट हो रहा है। जो रूल 3B है जो रिस्ट्रिक्शन को अलाउ कर रहा है, रूल 3B ऑफ द केरला हिंदू प्लेसेस ऑफ पब्लिक वर्शिप एक्ट, अनकॉन्स्टिट्यूशनल है, क्योंकि ये अलाउ कर रहा है ऐसे रिस्ट्रिक्शन को जो कॉन्स्टिट्यूशनल आइडियल्स के कॉन्सोनेंस में नहीं है। रूल 3B allowed for Hindu denominations to exclude women from public places of worship. If the exclusion was based on custom. Okay, there was a little glitch in the network. I'm summing it up now. The Apex Court has allowed entry of women of all age groups to the Sabrimala temple and held that devotion cannot be subjected to gender discrimination. Now, what was the obiter dictum? Let us see. Obiter dictum is a judge's expression of opinion uttered in court or in written judgment, but not essential to the decision and therefore not legally binding as a precedent. In this case, the court ruled thus: we have no doubt in saying that such practices infringe the right of women to enter a temple and freely practice Hindu religion. Devotion cannot be subjected to gender discrimination. Honorable Chief Justice of India stated in his judgment that religion is way of life linked to the dignity of an individual, and patriarchal practices based on the exclusion of one gender in favor of another could not be allowed to infringe upon the fundamental freedom to practice and profess one's religion. Okay. तो ये मतलब पूरा उन्होंने फिलॉसफी जो एक्सप्लेन करते हैं वो ऑबिटर डिक्टम में करते हैं कि ये क्यों हमने अलाउ किया है. सो इन्होंने कहा कि किसी भी तरीके से जेंडर डिस्क्रिमिनेशन, कोई भी रीजन रहा हो, बट जेंडर डिस्क्रिमिनेशन अलाउ नहीं हो सकते. ये राइट्स बहुत इंपॉर्टेंट है. अगर हमने इतनी बारीकी से सोचा कि ये यूं किया है और ये इस वजह से किया, तो ऐसे तो बहुत सारे फंडामेंटल राइट्स बहुत कोई ना कोई एंजॉय नहीं कर पाएगा. तो ऐसे नहीं कर सकते हम. The apex court has declared that the practice of restricting women of a specific age group in their menstruating years from Sabrimala temple is unconstitutional. Current status of cases, there are review petitions filed challenging the judgment pending. Now, what is the conclusion? The conclusion is that uh, freedoms related to religious are essential elements for the functioning of democracy in a country like India. And as we know, constitutional ideals and social reality are very different as much as possible for the smooth and proper functioning of society. In the case of Indian Young Lawyers Association versus the State of Kerala and others, Apex Court has tried to bridge the gap between constitutional ideals and social reality. Okay, so this is all about the Sabrimala judgment in a nutshell. If you have any questions, I'm willing to take the questions. Please do ask. The slides are not clear. Okay, you must have told me earlier then, because I zoomed it. I hope it was visible throughout the session. Okay, okay. Thank you, Aslesha. It was visible. So, if you have any question, please ask me. The bench constituted of how many judges? 5 judges bench it was. It was a constitutional matter. A constitutional bench, minimum number of judges on the constitutional bench is 5 judges. Okay, 5 judge bench is a constitutional bench. If the matter is being taken up for the very first time, it is the number of judges are supposed to be 5 minimum. If it is going to be taken up, if the matter was earlier taken up and some yet another development has taken place, so it is going to be 7 judges bench. Like for example, if this matter is supposed to be challenged again, and if it is supposed to be decided again by the Supreme Court, then it will have 7 judges on the bench. Okay, so in this case, since it was taken up for the very first time, so 5 judges were there. 5 judges means the majority जो judgment आया है, जो जिस ratio से आया है, वो 4:1 के ratio से आया है. See, I'm going to show you. 4:1 के ratio से आया है. ये देखिए, यहाँ पे लिखा हुआ है. On 28 September, the very first line. On 28 September 2018, the court delivered its verdict in the case by 4:1 majority. Okay. So there were 5 judges. Okay, welcome. So I hope it's all that you people wanted to ask. So I am ending the broadcast now. All the best. Thank you. Bye-bye.